Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
As a business and healthcare law firm, we meet a lot of interesting people and learn their amazing stories. Our clients commonly come to us with the latest word on the street that they heard from a friend. This season, Brad, we will talk about stories with a common legal urban legend to them, and we will seek to either prove or disprove the legend. This season's theme is fake or real.
Oh, yeah. I'm excited. Well, Michael, I don't know if you know this, but at our firm, we have 3 core values: communicate, create, and compete.
Yeah, Brad, I was with you, and so was Jay when we were developing these many years ago. Yes, but they are important to us. When we started the firm, we actually spent the better part of our first year in practice really trying to develop, what are our core values? And in our minds, the question was, what's our DNA?
Yeah.
What is it about us that we think makes us successful, and let's identify those things and hold on to them. And the communicate core value to us was our lesson learned in our kind of path as attorneys, that clients seem to value good communication more than anything. I think they assume that we're going to provide great legal work, but good communication is highly valued, if not the most important thing. The compete core value is the kind of grit element of, we know that, things are going to happen, and how do we as a team respond? And we had shown through the years that we could, whether it's something in our professional or personal lives, that we would get back to back and get through things. And then finally, the create core value is just that element of innovation, where we are looking for simpler, better ways to do things. Kind of one of the proudest things we have is Access Plus, our subscription billing model, but there's examples up and down the halls here of.
You mean like a lawyer starting a podcast?
Yeah. Something like that.
Something like that. I mean, yeah, that would be creating, competing, and communicating.
Exactly.
Interesting. Well, in the past show, we have discussed the infamous, I'm not sure if the right word there is, New York chicken Parmesan incident. I don't know if we should go into that anymore.
Yeah, Brad. I mean, I don't know, even though it is season 13, that I don't think we should relive how we acted like 2 13-year-old boys in the middle of New York with a table full of clients and friends and having an eating contest together, even if I did win.
I think, you're much older. That was a long time ago, Michael. So you're probably forgetting. I think if I remember correctly, it was a tie. Audience members, I won. But today's show, it reminded me about competition, and some can be good and some can be bad. And for example, would you ever want to eat hot dogs with Joey Chestnut?
I, for one, would not like to eat hot dogs with Joey Chestnut. He's a pretty famous person, and I can't hold up to his standards. But, I like context, and we know that someone in the audience might not know who Joey Chestnut is. And he is the all-time winningest hot dog eating champion in the country.
Yeah, that's right. Joey, who has eaten as many as 76 hot dogs and buns during Nathan's 10-minute hot dog eating contest that happens every July 4th. No other competitor has actually eaten more than 64 and a half, which I thought was funny that they got a half there. And according to USA Today, Joey now does eating contests full time, which sounds wonderful. And he's developed a net worth of excess of $4 million doing that. Joey defended his title last month. He clinched his 16th career win by scarfing down only 62 francs in 10 minutes. The second place finisher was not Michael Byrd, ladies and gentlemen, but that second place finisher did eat a whole 49 hot dogs. I'm just getting a little bit sick to my stomach just thinking about what's going on in Joey's stomach after all this.
It must not have been good eating conditions if he only got to 62.
I know.
And I know as much as it might sound great to eat in a contest full time for a career. It's pretty disgusting watching what they do to try to wolf all that stuff down.
Yeah.
But while we were sitting here, I did check with Siri, Brad, to see if I could find the world record for the fastest to eat chicken Parmigiana. And I was sad because I expected to see my picture, and I didn't.
So when you saw mine, did it throw you off?
I couldn't find anything. It was so weird. But I did find that a competitive eater out of the United Kingdom has the record for the most chicken nuggets eaten in a minute. Oh, God. Her name is Leah Shootkever. I don't know if that's how you say it. And sorry, Leah.
Yeah.
But I'm going to ask you and Jay, who's sitting nicely in the background, if you have a guess as to how many chicken nuggets Leah ate in 1 minute. You go first, Brad.
Is it like Price is Right? I can go under. If I go 1 million, that's too high. And if I say one, it's too low. Or
if you go over, you're kicked off the rest of the episode.
Riley, don't listen to him. Okay, I'm gonna go in 1 minute, 100.
Okay, you're so far over. I have to say that for Jay's benefit. All right, Jay.
I'm gonna guess 70.
Believe it or not, it's 19.
Oh,
that seems like such a reasonable amount, but the amount before that was like 10. But remember, this is 1 minute.
Okay, yeah. Joey's throwing me off so much.
I know. It's weird, unless of course Siri's wrong, which is possible.
Was it Siri or Chat GPT? Audience members, go back to the episode that we started the season with to understand the analysis in that one.
Yeah. So we do leave room if you want to fact check me.
Okay.
Go ahead and Google that.
All right.
Okay. Well, I do not think it's a coincidence, Brad, that you brought up competition today, because Jay, who's joining us and you've just heard, is one of, if not the most competitive person here at the firm. And you wouldn't know that if you met Jay. And there's clients out there that have known Jay for years that are thinking, no, there's no way, that smart guy.
So nice.
Calm.
Yes.
Well, let me tell you, when he was a young associate and he was put in charge of our old firm's kind of recreational basketball team, intramural basketball team, and we showed up and Jay started barking orders at everyone. I was like, who is this guy? It was a new perspective for Jay.
Yeah. I came in guns blazing there, just telling everybody what to do. And I will neither deny or confirm that I might have left some people off of the email list to gather for the game based on skill set ability. But I've mellowed a lot. Now I'm more of the silent assassin type. If you guys remember, we did bowling for the firm anniversary, and we're going to do a competition, and we found out about it maybe 3 weeks before. I love bowling, but I hadn't bowled in years, and I convinced my wife to get our kids out for a nice family afternoon of bowling like a week before, just to knock some of the rust off. So basically they were joining me for my bowling practice. But I will have to say, I still have the trophy in my office from that afternoon, so it paid off. But yeah, I've mellowed out a lot. I don't coach my kids soccer.
I'll just say this: one of our associates at the time, I guess he still is 6'7".
Yes,
and I remember him saying, Jay really bossed me around a lot. So
hustle. He's got to hustle. He's got to rebound. I didn't put him out there for fun.
Oh my goodness. Well, I'm sure we could spend the rest of the episode talking about the many examples of how competitive we all are. Yes. But we probably should get into today's story.
Yeah, and Jay, I think you have today's fake or real story. So let's get started.
Yeah. So today's main character we're going to call Dr. Melanie. Dr. Melanie is a successful surgeon up in the Northeast, maybe around the New York area, and she had an opportunity to work with a childhood friend, a fellow surgeon named Dr. Jake. And this was back in our hometown in the South, let's say somewhere in Alabama.
Gosh, Jay, I'm glad you're on this episode. And for those audience members who don't know, and Michael Byrd, who does not know, Jay is referencing the movie Sweet Home Alabama, which I'm really excited about because that's a 2002 movie. And I know Michael always makes fun of me because, I'm always stuck in the 80s, apparently.
Hey, Brad, remember Michael banned movie talk, so that's about all we can talk
Okay,
about.
well, yeah, Riley, just cut anything Michael says after this.
I don't know whether to object to the movie talk or make fun of you both for bringing a rom-com into the mix. At least before, you would always go sci-fi.
Yeah.
Even if I did shed a little tear at the end for Reese Witherspoon and her love interest, Josh Lucas.
Yeah. No spoilers, though.
Oh.
Spoiler alert. Well, so Dr. Jake, he had given Dr. Melanie a contract to consider, and Dr. Melanie wanted me to review and help negotiate it. So the first thing that I did is I hopped on the call with her and had the plan A, plan B discussion for context before I actually jumped into the document to review.
Yeah. And Michael, we've talked about this before in other shows about plan A and plan B. But for our audience, maybe hearing this for the first time, since Jay used the word that you love so much, context, maybe you can give some context on what plan A and plan B means.
Yeah, plan A, plan B is how we center the discussion. So a contract is a piece of paper with words, and it really comes to life if you understand, in this case, our client, what are they trying to accomplish? And the plan A, plan B is an exercise where we want to understand, if this goes perfectly, what does this look like? That's kind of the plan A.
Mm-hmm.
And then the plan B is, if it doesn't go perfectly, what are the contingencies? And then you can see, does the contract align with that,
right,
or not? And that helps identify kind of issues that you may need to deal with in the contract negotiations.
Yeah. And for audience members who didn't catch it on, I mean, that's so important. That's why Jay started there, because it does help us determine those next steps. And so, Jay, what did you learn from Dr. Molina when you actually had a chance to talk to her about her plan A, plan B?
Yeah, so I learned that she was wanting to move back home primarily to be closer to family. That was the whole point of the move, and really just even looking at the opportunity. And this was a permanent move too. There wasn't a short-term type issue. It was, I want to move home. I want to be there. And so it was very, very important for her to be there and to stay there long term and completely relocate. Again, she was a successful surgeon up in the Northeast, to completely relocate and establish roots again back at home.
So did she express any particular questions or concerns about the contract?
Not really. This was, again, you go back to, Dr. Melanie and Dr. Jake had been having discussions for several months, and they had this, this long-standing relationship. And so there's a built-in level of trust there between the two. And so really, Dr. Melanie felt that the contract, contained the things that they had discussed. And, at the end of the day, what I got and kind of what she said without really saying it is, she was really just checking the box of having an attorney review it.
Yeah. And it's not uncommon when you have friends or people that have that trusting relationship that you just mentioned, Jay, to be able to get there. Now, what can go wrong sometimes is, they don't really talk about the things they need to talk about, or that they know they need to talk about. But I'm guessing here the review was pretty straightforward.
Not exactly. So, open it up, fairly standard physician employment agreement, go through many of the terms. And, for the most part, yeah, they're balanced and fair, things that I expected to see. But then as I got through kind of to the middle of the document, I found, one area that was really kind of alarming that Dr. Melanie didn't mention, didn't raise an issue, but it was, clearly right there in the middle of the agreement. And there's a non-compete. And not only was there a non-compete, there was actually a decent sized radius to consider. And so that, I was shocked that that wasn't something that was raised or talked about when she mentioned it.
Yeah, it's pretty scary. She's moving back to her, I guess I'll say, sweet home, Alabama. Now, understanding that, Michael, going back to plan A, plan B, talk about the interplay that non-competes have with that analysis.
Yeah. First, Riley, put your finger near the microphone for Brad. If he starts threatening to sing again, we're going to have to shut this thing down. Oh, no. This is getting bad. Yeah, we have, as you mentioned, Brad, we've talked about this on prior episodes. And if your plan A is to move home and you want to be home, the non-compete obviously is a direct impact on that. So what's your plan B? Well, if this contract doesn't work, you still want to be home, but you won't be with this practice, and this non-compete would inhibit that. And so I would agree. This is really surprising that in the course of this trusting relationship and your conversation with her that she didn't mention that.
Yeah. And all the same thoughts that I had. And so, I knew once I had, looked through the rest of the agreement that the non-compete was really going to be, the primary focus of my conversation with Dr. Melanie. And, again, she'd expressed the move back home was going to be permanent. And then here's this non-compete that, if the arrangement didn't work out, it was going to prohibit her from being within a good size area away from home. And so I knew this was going to be really the focus of the conversation and not so much any of the other things, since they did kind of align with what our expectations were.
Yeah, this really does not sound like an ideal situation for her, especially in light of the fact she's moving home to be with her family. What did you say when you had that conversation, and what was her thoughts about the non-compete? And I guess you had to bring her attention to it.
Yeah. I mean, I started with the conversation. Hey, I went through the agreement and I noticed that there was a non-compete and just wanted to see, what your thoughts were, just to hear what, if she had considered it or had any thoughts. And she basically said, oh yeah, she saw it. She just wasn't worried about it.
Why?
Yeah. That's what I was wondering. She said that she had heard that non-competes were banned and non-enforceable. And so, that's obviously where I spent the rest of the conversation kind of talking through that particular statement.
Yeah. This is actually a modern evolution of an old conversation. So for years we would talk, in fact, we've talked about this in other episodes. The locker room talk is non-competes are not enforceable.
Yes.
And so they have this misconception based on what other doctors tell them about the law. Well, the federal government decided to complicate matters. So the Federal Trade Commission, or the FTC, issued a proposal earlier. I think it was, just months ago, earlier this year, that said that proposed banning non-competes across the country. And so we have gotten so many phone calls from existing clients or situations like this where there's this assumption that non-competes are no longer enforceable.
Yeah, and for those who don't know, the Federal Trade Commission, or as Michael called it, the FTC, is an independent agency of the United States government whose principal mission actually is the enforcement of civil antitrust laws and the promotion of consumer protection. So that's its purpose in life. But as Michael was mentioning, for those who didn't know, January of 2023, the FTC did propose a new rule that would basically ban employees from imposing any non-competes on their workers.
Yeah, well, that was a much fancier way to say what I said, Brad. You using big words over there, but yeah, that's the kind of lay of the land of what we are seeing in 2023. But let's pause. Let's go into commercial, and when we come back, first we need to answer the question: fake or real? The FTC has banned all non-competes, and then unpack some considerations that go with that.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back to Legal 123 with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd. We're still sitting here with series regular Jay Reyero. Now, Michael, this season theme is fake or real, and we have a big question that everyone wants to answer.
Yeah, I mean, we have a rom-com themed story today,
Yes.
although I'm really disappointed that Jay didn't bring the rom into the story.
No.
Brad's been supplying the com with his singing, but really getting down
My
to
award-winning singing is what I heard.
Yes, Brad. The story today is the idea of this doctor had a practice in New York, going home to Alabama, joining a practice with a friend, Dr. Jake. And there's a trusting relationship, and all is great, except when Jay looks at the contract, there's a non-compete that Dr. Melanie didn't mention. And so what Jay came to find out is she thought non-competes were banned, so she didn't worry about it. And what we talked about just before the break is that she was relying on the announcement from the FTC that all non-competes should be banned, the proposed rule. But before we answer the question, Jay, how do states throughout the country view non-competes kind of before the FTC proposal, especially as it relates to doctors?
Well, so as we always like to say, it's truly state dependent. So every state's going to be different, and they're going to have different variations of their non-compete laws. We can kind of break them down into 3 different buckets. So, on one end of the spectrum, they're not enforceable. They're unenforceable by law. So states, California, Colorado are examples where the physician employment non-competes are going to be non-enforceable.
Mm-hmm.
On the other end of the spectrum, we have those that are enforceable by law. So states like New York and North Carolina are going to be examples of those states. And then we, of course, have the ones that are in between where they're enforceable, but we have some strings to attach to them. So great example is Texas, where it's enforceable against a physician, but there are very specific requirements that are set out by statute that the non-compete has to meet, one of which is that it has to contain a right for a buyout of the covenant. So kind of have those three different buckets, that spectrum, if you will, and the states will fall in the various different buckets, but it's different all across the country.
Yeah, and I think the first big takeaway from Jay's perspective, as he was describing it, is all states dislike non-competes. It just depends on how far they'll push it from the factors. And another example of taking that to a different level is the state of Massachusetts, where they really severely restricted an employer from enforcing non-compete. So again, it's going to be allowed in their state. So the Massachusetts Non-Compete Act makes it really hard for employees to have a non-compete in their and find ways in which to have a non-compete enforced at all, although they can have it. So not only must the non-compete be part of a written agreement in Massachusetts, it has to say that the employee has a right to get an attorney. The employee has a right to have basically 10 days after they sign it to basically get out of it if they want to. The act also requires the non-compete agreements to be fair and reasonable consideration that's independent of the continued employment, along with the complying with reasonable time geographic restrictions, which is most states have that. But the non-compete also must protect legitimate business interests. You can't throw in the kitchen sink, basically. And it must be consistent with what they deem public policy. But this is the part, all that's kind of somewhat normal in a lot of different states, audience members, but understand where it really shifted. And it's the most notable is they have something called included that employer has an obligation to include a garden leave provision and the non-compete.
Well, that sounds so pleasant, Brad. Tell us what a garden leave provision is.
Apparently, it's about doing the garden when you have so much time you can go gardening.
Oh.
Yeah, but in context perspective, the garden leave clause is a provision requiring an employee to pay an employee post-employment. Right. So they're not working for you anymore. And during that restricted time frame, you still have to pay them if you want to enforce that non-compete. So what does that look like? Well, in Massachusetts, they basically said you need to go back and look at the highest amount of money they earned and then pay them 50% of what they were earning during that time. And you just prorate it during that restricted covenant, meaning that if you want someone not to work for you and you were paying them $100,000 and you want 12 months, you're paying them $50,000 to sit around and do gardening. I don't know, Jay, I think this actually should be called like the movie provision or maybe the gaming provision. I don't know if people even garden anymore, but consequently, as you can tell, if other states start seeing this being fine, you can have a non-compete, but you have to have a video game provision or a movie provision or gardening provision as part of it.
Yeah. And probably we could go on and on talking about the nuances on a state by state basis, but I think we're ready. I'm ready to hear the answer. So Jay, fake or real, the FTC has banned all non-competes.
The answer is fake. For right now. Brad mentioned the rule being proposed back in January of this year, but there's more to the process before it becomes a law. So what typically happens is the federal government agency will send out a proposal and say, this is what we're proposing. And then they ask for the public to submit comments for a certain period of time. And that's what happened here. So the comment period was earlier this year. and then the period closes. And then the government kind of takes the proposal, looks at all the comments, and then they use that to develop a final rule that is then voted on. And so that period for comments closed, all the comments came in. There was, as you can imagine, a significant number of comments that came in. And so the FTC now has to take the proposed rules, take the comments, evaluate it, develop the final rule, and vote on it. Well, recently, word came down that the FTC isn't expected to actually vote on a final version of the rule that they create until April of 2024. So at this point, nothing has changed. The FTC has not banned non-competes. They haven't done anything. And we're still about a year away to find out what the actual final rule will be.
Yeah. And Michael, the follow-up question I think every audience member probably wants to know is, assuming the FTC does in fact ban all non-competes, is that the end of the story?
No, actually, it's going to be a massive controversy because non-competes, as we've talked about on the show, are state-driven. So a federal agency passing a sweeping law that overrides state law, as we learned in law school, is a big deal.
Yeah.
There's a lot of stuff in the Constitution about state laws and state rights. And so there will be a lot of litigation fighting over whether or not the FTC even has the authority to make this particular change to the law.
Yeah, great point. And I'm glad you brought the Constitution in, since you were there when they signed it. Now, and since we know the answer is fake for that right now, when you find yourself in a state where non-competes are enforceable, what are some of the common essential requirements that at least that state must meet?
Yeah, kind of thematically, the states look at, did the physician get something of value to agree to the non-compete? Now, this can be really tricky. So in some states, it might be a bonus, right? Like, you're getting this $10,000 bonus in exchange for agreeing to the non-compete. And in some states, that's not allowed. Like Texas, that would actually make it an invalid non-compete. And what tends to work in most states is, if you, the physician, are getting to receive confidential information, the secret sauce of the business, then that can be valid as something that the doctor gets. And so as a result, they're going to give a non-compete. And then from there, all the states kind of have this reasonableness on the restrictions kind of standard. And what you tend to see is it needs to be reasonable on the amount of time. So how long is the non-compete in place? You tend to see anywhere from 1 to 2 years. You start getting outside of 2 years in most states, that's going to be problematic. The geographic area, if you have a non-compete that covers the entire country, that's probably going to be unenforceable in most states, and not all states. And so then the third is, what activities are you restricting? If you have, a spine surgeon that's restricted from practicing medicine at all, is that going to be too broad of a restriction, or do they just have to be restricted from doing spine surgery?
Yeah, all good points. So, Jay, given that the FTC has not, at this moment in time, banned non-competes, what ended up happening with Dr. Melinda?
Well, I wish this episode would have come out then, because I could have just had her listen to this, because I basically had the exact same conversation that we all just had here, explaining the state of things on the FTC and the process and how nothing's really changed. So really disproving the myth that she was relying upon. And then, talking with her, she was actually heading to a state where non-competes were enforceable. And so we had the in-depth discussion that Michael just talked about how they view it and things that you have to consider and the risks. And so we had that very in-depth conversation really about plan A and plan B and how the non-compete were in conflict. Ultimately, she understood, and she was able to talk with her good friend, Dr. Jake, and negotiate its removal because of their relationship and trust. And it ended up working out for her.
Was there a song played at the end?
Yeah, there was a song. There was a nice dance in a bar in the middle of a thunderstorm. It was beautiful.
That's why I had the ramen there. All right, Jay, final thoughts for our audience here.
Yeah, key takeaway is nothing has changed from the FTC ruling, so it's something to keep an eye on. And even then, as Michael said, there's still going to be a lot of unknowns, but you still have to now just focus on your state rules. And going to Dr. Melanie's case, if you're an employee being asked to agree to a non-compete, you just can't simply rely on they are not enforceable argument that you may hear from a friend or that people will say. You really have to understand how that state that you're going to really handles non-competes, and that'll help you make a better decision from a plan A, plan B perspective.
Awesome. Michael, your final thoughts.
Yeah, I mean, one thing to watch is kind of a ripple effect of the FTC, or it seems like that, is whether the states start taking their own action. We're seeing New York that's trying to ban non-competes. We've seen it in other states. And so I will be curious to see if there's a momentum or movement towards banning non-competes that goes, at the state level, which is going to be much more survivable if that happens. There will be less litigation. And then the final thing is this: if you're an employer and you're looking at it, to understand that there's more to it. We've talked about this in prior episodes, that there's more to it than just having language that says you can't compete. Enforcement of these are difficult. They're expensive, both in terms of money and time commitment and emotional commitment. And so there's a lot of variables that come into play when you're looking at enforcing one of these.
Yeah, all good points. Well, audience members, that's all the time we have today. Sorry, we can't sing Sweet Home Alabama for you. But next Wednesday, we will continue our quest to determine if a legal myth is fake or real when we examine fake or real. CPOM, or corporate practice medicine, may affect the business structure of my med spa.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.